All right, good evening to everyone. This lecture will be about Hannah versus Peele. And so I'm assuming by this point that you've read Hannah versus Peele and have some familiarity with it. In what follows, I'm going to explain to you the essential holding of the case, and we'll think about how it relates to the previous rule that we learned when we read Bridges versus Hawksworth. Before I begin turning to some of the finer points of this reading, I think we should understand Hannah versus Peele as a refinement of the general rule of Finder's law. You might recall that from Armory versus Delmiri, repeated in Bridges versus Hawksworth, is this idea that the finder of lost property acquires superior title to that property over and against the entire world, except for the rightful owner. And since the finder has superior title to the entire world, he also has superior title to the person who owns the property on which the lost item was found. And the person who owns the property on which the lost item is found is called the owner of the locus in quo. So if you think of it as finders keepers, that's basically right, as long as you understand that the finder has a defeasible title that can be defeated by the true owner who might come forward and prove prior ownership. Now, the two exceptions that the court talked about in this case are intuitive exceptions. One, you might think that, well, if somebody owns a house, a finder shouldn't be allowed to just come along and find whatever they want in somebody else's house. That might be a limitation on finder's law. The second clear exception to finder's law involves an inn. You might think the innkeeper has a special fiduciary relationship with their clients, and they're responsible for keeping their clients in just as good an economic position as when they walked through the doors of the inn for the first time. And so finders keepers, unless you're in an inn or in somebody's house, or unless the true owner comes forward and can prove, not just assert, but prove prior ownership. That's all we have so far from Bridges versus Hawksworth. It's the law of England and the English common law with which we're working today. And Hannah versus Peele proposes an interesting variation on this case to help us test the limitations of the rule. Before I begin explaining that, however, I might do something a little bit fun and show you where this property was located. So the name of the estate that is the locus in quo, or the property in question, is called Gwrnheilod. It's located in Wales, and at one time in history, it looked like this. It was a beautiful house, a massive house, really, but it fell into disrepair and was ultimately torn down, I think in the 60s. But here it is. You might notice that it's located on this River Dee, and it has this sinuous kind of pattern to the river. It helps us kind of locate where it would have sat if it were still standing today. Now, I found on Google Maps this map, and you can see the river kind of taking the same course around this area. Lo and behold, right where Gwrnheilod used to stand, there's now some dwelling. Now, when you zoom in on this house, you'll notice something about it. It looks very much like the Notch O, the Ohio State logo. And I can only imagine that Ohio State would love to sue the owner of this house for copyright infringement, just as they've done with the Overtime Company and more recently the University of Oklahoma, who's put the Notch O. Really, they've had the audacity to put the Notch O on their drum major. Okay. Well, let's stop talking about silly things like that. I'd like to emphasize first the timeline of this case, which is the most interesting, I think, part of the case. But we need to master it if we really understand the facts of the case and what was going on. So in December 13th of 1938, Gwrnheilod was conveyed to Peele. Now, at some point in history, I used to think that it was conveyed by will. I thought that someone died and conveyed it to him, because a major in the army doesn't seem like the kind of person who would customarily be buying mega mansions and large estates in Wales. But since we learn later at the very end of the case that the predecessors in title were thinking about making a claim that would have been relevant to the legal results, it leads me to think that Peele actually did buy this property, and that as a result of the purchase, it was conveyed to him in a very much normal manner. Okay, so however it was conveyed, though, It was conveyed to him December 13th of 1938. Now, events were happening in the world at this time. Great Britain went to war with Germany, and on October 5th, 1939, this mansion was requisitioned, which is a way of saying it was taken over by the British government for the express purpose of furthering the war effort. But shortly thereafter, the strong-armed approach of the British government ceased, and it was released from requisition. Now, I think we're to believe that because it was released from requisition, and because ultimately some other parties who were soldiers were stationed there, I think we're to believe that Peel actually leased this property to the British government. So it wasn't requisitioned at this point, but it was voluntarily leased, and Peel was economically benefiting, I think, from this exchange. This is just extrapolation based on the few facts we have, but I suspect that this is what's happening. Now, at some point after, presumably, the estate's being leased to the British government, the plaintiff Hannah is stationed there. And a little bit over a month later, he's adjusting the blackout curtains when his hand finds something in the windowsill. At first, he thinks it's just a piece of plaster, so he puts it away. But in the morning, when the light comes through, he discovers a dusty old brooch. Hannah, at the insistence of his commanding officer, hands the brooch over to the police, and almost 2 years later, Peel, the owner of the house, goes to the police and somehow picks it up. And this is what I find to be the weirdest part of the case. Hannah, the finder, takes the brooch to the police, but later it's Peel who somehow retrieves it from the police. I don't know why the police did that. In any case, Peel has less than noble intentions, it looks like, because he immediately, not immediately, but a couple months later, sells it to a jeweler for 66 pounds, which in today's currency and converted to US dollars is about $4,500. So this is something that I definitely like to find one day. Now, another thing that we don't know is when exactly Peel sold the brooch to the jeweler. It just says that it was sold to the jeweler in October of 1942. We also know that the plaintiff Hannah, by lawyer, demanded the brooch back from Peel on October 5th, 1942. So wouldn't it be something if Peel got the letter from Hannah's lawyers and then in light of that letter, just took the brooch straight down to the jeweler and liquidated it? That would be consistent with the facts. It would also be consistent with the facts that Peel antecedently took the brooch to the jeweler before ever receiving this letter from Hannah. So maybe he's more noble-minded than I thought. But in any case, he doesn't look very clean to me. But let's let one more year pass, and then on October 21st of 1943, Hannah sued Peel in debt new. Now, recall the actions that were possible. Trover was this action in which you're trying to get back the value of something that was wrongfully detained. Replevin is an action where you're trying to get back the item itself. And debt new is when you don't care. You'll take the item or its value. Okay. So in light of these facts, I think this is a very good opportunity for us to look back to our acronym IRAC and practice thinking like a lawyer for a bit. So recall that when we're thinking about the IRAC method, we're trying to extract 4 bits of information from the legal reasoning. We're trying to find out first the issue that's being considered. We're second trying to figure out the rules that are at play. We're then trying to figure out what reasons support adoption of one rule rather than another. And then lastly, we're trying to figure out the conclusion, which is to say the rule applied to the specific facts under consideration. What result do those rules favor in the present case? So let's start first with our issue statement. This should be the easy part. And just like any good legal writers, the judges in this case have put the issue right up front. The issue right up front is whether the finder of lost property or the owner of the locus in quo have superior title to lost property found on the locus in quo if the locus in quo is a house that the owner does not currently occupy. That's very interesting, right? Because in Bridges versus Hawksworth, the lawyers made constant reference to the idea that you couldn't just go to somebody's house and find something therein. All the interesting cases seem to happen outside of the house. Well, what if you own a house, but you don't live there? That seems to be the legal question under consideration. And you can see the judges themselves put the issue very succinctly when they say, the plaintiff says, I claim the brooch as its finder, and I have a good title against all the world save only the true owner. And the defendant, Peel, says, my claim is superior to yours inasmuch as I am the freeholder. I own the real estate. I own the locus in quo. I have the best possible title to this property. Finder says, I have these finder's rights. The owner of the locus in quo says, I own this property in fee, which is an archaic way of saying I have the best possible property rights to this real estate. Okay. Now, the two rules that will be combating in this case, Hannah's preferred rule is just to apply the rule from Bridges versus Hawksworth and to say that it doesn't apply to the premise on which the brooch was found because Peel doesn't actually live there. It's not his house, and it's not protected by those manorial rights referenced in Bridges versus Hawksworth. And Peel wants to say, no, the finder's law does not apply to any sort of private dwelling, regardless of whether or not it's leased or requisitioned or whatnot. And so who's going to come out on top? Well, in figuring that out, we're going to have to consult the common law and to see what cases are at play in this instance. Now, the first case, of course, is Armory versus Delamere. The court references this case. I referenced it in the previous lecture. The facts were very simple. The chimney sweep found the ring and took it to be appraised, but the jeweler, the goldsmith really, keeps some of the stones and won't return them to the chimney sweep. And so even though the chimney sweep doesn't have the best possible title, might he still be entitled to the return of the stones? The answer was yes, of course. A finder has superior title against the entire world, except for the rightful owner. So even though the chimney sweep obviously doesn't have the best possible title to the ring, he's got better title to the entire world, including the jeweler, and so he's entitled to return the stones. This is applied in Bridges versus Hawksworth to give Bridges superior title to the notes since he was the finder and since the true owner never came forward. And so in this case, we'll have essentially three analogous cases to consult. Analogous cases, of course, are just those cases which have substantial similarity of fact. And in all these cases, you have essentially a finder who asserts a claim against the owner of the property on which the item was found, i.e. the locus in quo, right? So our three cases that we'll need to consider are Bridges versus Hawksworth, South Staffordshire Water Company versus Sharman, which is quite difficult to say quickly, by the way, and Ewells versus Brigg Gas Company. All right, let's look first at Bridges versus Hawksworth. I think this will already be familiar to us since we just covered it in the previous lecture. But I have a bone to pick with one thing the court here in Hannah versus Peel says about the reasoning in Bridges versus Hawksworth. They criticize the lawyers there because neither counsel put forward any argument on the fact that the notes were found in a shop. Counsel for the appellants assumed throughout that the position was the same as if the parcel had been found in a private house. And the learned judge spoke of the protection of the shopkeeper's house. I disagree with this. I think that Bridges attorneys made reference to the privacy of a home as being sort of paramount, but there are lesser degrees of privacy, and you could sort of see that there were lesser degrees of privacy when you considered a road as compared to a field and a shop being somewhat more private than a private field and whatnot. And so you might think by extension, a shop is less private than a house. And because a shop is less private than a house, the manorial rights that apply only to houses don't apply to shops. It's sort of a suppressed kind of argument. And I think the court in Hannah versus Peel could have been a bit more charitable in bringing that out. And so it just goes to show you that Hannah versus Peel is full of jurists who interpret these cases just as we do, and they draw different conclusions. But in fact, many lawyers during that time all had different interpretations of Bridges versus Hawksworth because much of the reasoning was unclear, unequivocal, and it wasn't clear. I'm sorry, the reasoning was equivocal, and its extension wasn't quite known at the time. So it's a very controversial and kind of unclear case. But the first case, of course, is Bridges versus Hawksworth, in which the rule from Armory versus Delamere was repeated. Finders keepers, essentially, unless the true owner comes forward, or if it's in a house, or if it's in an inn, right? Those were the results we derived from Bridges versus Hawksworth. Our second case for consideration is this case of South Staffordshire Water Company versus Sharman. Now here, there's this water company that owns a pool called Minster Pool, and they hire Sharman to clean it out. Well, in the course of this cleaning, Sharman finds 2 gold rings that are embedded in some muck. And once again, you have the finder versus the owner of the locus in quo. What is Sharman saying? He's saying that he has superior title to the rings over the entire world, which includes the water company. Why? Because he's the finder. Now, in this case, the court actually finds for South Staffordshire Water Company, and it's not completely clear why they've done so. It could be because they think that the owner of a locus in quo presumably owns everything embedded in the soil of his land. You could distinguish that result from Bridges versus Hawksworth, because in Bridges versus Hawksworth, the item that was found was just a movable. It was a bundle of notes that was sitting on the surface of the land. But in South Staffordshire Water Company, the rings were found embedded in muck, in water, in other words, the land of the water company. So you might think the court has decided to fine for the water company because of the location of the item. They weren't on the surface of the earth. It was embedded in the soil. But the quotation is a bit confusing and might lead us to think otherwise, right? The quotation here is that there is no more direct authority on the question, but the general principle seems to me to be that where a person has possession of a house or land, here's the interesting bit, with a manifest intention to exercise control over it and the things which may be found upon or in it, then if something is found on that land, whether by employee or the owner or by a stranger, the presumption is that the possession of that thing is in the owner of the locus in quo. Now, why would we no longer think that the location of the item is relevant? Well, we just had this nondescript statement about it being found on that land, not embedded, but merely on the land. The interesting thing is there's a manifest intention to exercise control over the land. How might one do this? Well, you might put up a fence around your land, right? You might try to keep away any trespassers. You might take special precaution to keep the public or anyone who might otherwise wander onto the land out. You might put up a security guard. You might patrol the area with a horse. There are all sorts of ways you might manifest an intention to control. As of this description, it's grossly underdescribed at this point. But one mark for why the owner of a locus quo might prevail over a finder is if they manifest this clear intention to keep people out of a certain place. That would make sense of the results between Bridges versus Hawksworth and South Staffordshire. In Bridges versus Hawksworth, no such effort was undertaken to exclude the public. In fact, the public was invited to that business for business purposes. Meanwhile, in South Staffordshire Water Company versus Sharman, the company putatively exercises very tight control over the land. They disallow people from wandering into Minster Pool, and only for the express purpose of cleaning was it that Sharman was allowed to be there in the first place. So maybe if one exercises this special kind of control over their land, they'll be able to prevail over a finder. That's our first clue. And that's our first distinguishing case that helps us do some work in finding out what the result might be in Hannah versus Peel, isn't it? But before we apply the results from South Staffordshire to the present case, let's look at one last very confusing case, the case of Yules versus Brigg Gas Company. Now, in this case, A lessor leases his land to a gas company, and he retains only mineral rights. This is to say that if a gas company were to find gas, oil, that sort of thing, they could extract it and it would be theirs. Anything found in that capacity would become their property. But if they were to find, say, gold, silver, or some other kind of mineral, the lessor would retain those because he had retained mineral rights. Now, what happens, do you think, when the gas company finds an ancient canoe that's, by the way, still on display in the museum? What happens when they find a canoe? Well, here's where it gets disappointing, because the justices here seem to work from the idea that the canoe should go to the landowner or the lessor and not to the gas company. But they don't really care, it seems, why that's the case. And that seems to be what we would be most interested in as those interested in legal reasoning, right? They say, hey, either the canoe is a mineral or he had possession of the canoe at the time the lease was created. How might he have possession of the canoe? Well, one answer is just that an owner of land presumptively owns all things embedded in the soil. And so the lessor here owned the canoe at the time at which the lease was created to the gas company. But then there's a question about why that ownership right wasn't just transferred along with the lease. It confuses me and it perplexes me deeply, and the justices never considered this question. But nonetheless, we do get from this case at least one thing that we can grab onto and make sense of, and that's the idea that an owner of land owns all things embedded in the soil. So what do we do with all this? I mean, we have a few different remarks that we can make in Bridges versus Hawksworth. A 65-pound bundle of notes were movable. They weren't embedded in the soil in some way. Whereas in Ewells versus Brigg Gas Company and South Staffordshire Water Company versus Sharman, the item was embedded in the soil in some way. Now, you might think that the owner of land presumptively owns everything embedded in the soil. Maybe the rule is just if the thing is movable, the finder prevails, and if the thing is embedded, the owner of the locus in quo prevails. But neither of these cases would directly support that idea. If that were the rule, it'd be very easy to decide Hannah versus Peel, because you just might think the brooch was movable. Obviously, Hannah just reached and moved it from the windowsill. It wasn't embedded. It wasn't in the land. If that were the case, then Hannah would prevail because he was the finder of a movable. But the law doesn't seem to go in that direction, does it? There's something else that's mentioned in South Staffordshire Water Company versus Sharman, which actually is the legally relevant fact on which the reasoning will turn here. And it seems to not really come out explicitly in this case. And so retrospectively, since I know the English law now, it's easier for me to see why it was heading in this direction. It's easy to see how the law took the trajectory that it did. But I'm here to tell you today that the exercise of control, this fact that was discussed regarding South Staffordshire Water Company versus Sharman, ends up being more dispositive here. The idea there was that one who exercises a control to exclude people from their land or their property looks like they'll have the rights needed to defeat a finder's interest in finding a lost item. If I have a house and I exercise the typical kind of control over that house, and I disallow strangers from coming in willy-nilly, then I'll defeat any kind of finder's claim to any lost property that's found in my property if I manifested this intention to exclude people. Now we can use this and think about the present case. Did Peel, as the lessor of this property, did he manifest the requisite kind of control needed to exclude people from his house? The idea I think we're supposed to get is that no, he did not. By leasing his house, he gave up some of his manorial rights. Those who occupied his house found it to be more like a public place. And so even though he did have the best possible title to this property, the property being not requisitioned by the British government at the time at which the brooch was found, was presumably leased by Peel. And if it was leased, he's given up his manorial rights. He's made what would have been at least a private place into a more public place. Again, it's just a question of degree, as Bridges' lawyer said in Hanna versus Peel. A shop is more private than a field. A field is more private than a highway. A leased house is less private than one's own house, right? So I think we're supposed to think of it like that. Now, since the house is not entirely private, since some of those rights have been given up, it's fair game for Hannah to find things in the house as a tenant there. Zooming out for just a moment, you might think that there is a set of facts in which this would be just a manifestly unjust decision to deprive Peel of rights to anything found within his house. Let's say that the house actually was requisitioned by the British government. I have a house and the British government says, I'm sorry, there's no Third Amendment. You must give your house up to be used as a barracks or something like that. Oh, and by the way, any lost property that's found while we've requisitioned this house from you wouldn't go to you. Anything that you would have been able to have good title to as the owner of your manor would in fact go to somebody else. And this is the case because we've commanded it as the government. You might think that would be a very unjust result. It seems not to be the case here, though. It does seem to me that since the case explicitly mentions that the period of requisitioning had ended, it seems to me that Peel is more or less voluntarily renting out his house to the British government at this point. So he's a landlord, and because he's a landlord, he's sort of given up his rights to the manor, and the tenants, those occupiers of the house, acquire some interests that they wouldn't otherwise have had. Going forward, what we'll take from this case is that there is an improvement being made to the general rule of finder's law. Recall that it sort of evolves. In Armory versus Delamere, we simply have the statement that the finder of lost property acquires superior title to the entire world except for the rightful owner. In Bridges versus Hawksworth, we see some accessions made to that rule. The improvements are that this rule is limited because it doesn't apply to private homes, private manors, and it doesn't apply to inns because of a special relationship the innkeeper has to his clients. And so Hanna versus Peel, I'd like for you to understand as another and further improvement to this finder's law that's been constantly evolving. What is the improvement? Well, now it seems that the rule from Hanna versus Peel is that a finder of lost property acquires superior title to the entire world except for the rightful owner if the locus in quo is public. But if the locus in quo is private, it still seems open at this point that the owner of the locus in quo could prevail over a finder. And what we learn from the court's interpretation of South Staffordshire Water Company versus Sharman is that whether a property is considered public or whether a property is considered private hinges on the degree of control exercised by the owner. If the owner allows certain people to be in that property, the less it looks like the property is private. And the more people that the owner permits to be on that property, the more the property looks like it's public, which will help us figure out whether one is in the purview of finder's law. Okay. So the last thing I'd like to flag before I end this video is just that poor Hannah was awarded 66 pounds. Hey, it's still $4,500. It's not nothing. But the jeweler, we learn, ultimately sold this brooch to somebody else for 88 pounds. Why didn't Hannah, as the finder, get 88 pounds? the price for which the brooch was ultimately sold by the jeweler? I leave you to consider that question. I'll talk to you in the next video in which we discuss a transition to American law in the case of Goddard versus Winchell.